Good day to members of the media and to all those who are listening to this video recording. The topic I wish to address you on is the impasse between the government and the Director of Public Prosecutions, hereinafter referred to by me as the DPP, concerning the rental agreement of the building at 15 to 17 Park Street in Port of Spain. I was asked by some members of the media to give my views on this apparent impasse at which the DPP and his staff were intended to be relocated from Richmond Street to Port of Spain. At that time, I did not have all the relevant facts. It was necessary for me to ascertain the relevant facts before expressing my views. Those relevant facts are as follows. 1. In order for the DPP and his staff to meet the demands caused by the legislative and administrative reforms of the government for the prosecution of criminal cases, Cabinet agreed to increase the complement of lawyers and administrative staff at the office of the DPP and to relocate the office of the DPP because the DPP and his staff needed more office space to accommodate the full complement of staff of the DPP. 2. It was the responsibility of the government to identify such a building for the DPP and then to consult with the DPP to get his approval that it was a suitable building to accommodate him and his staff. The building identified by the government had the required square footage to accommodate the DPP and his staff, and it also had the parking spaces for his staff. 3. The building was in close proximity to the East Dry River communities, an area which was identified by the Trinidad and Tobago Police Service, TTPS, as a hotspot area. This meant that the area had a high incidence of gun-related crimes. The eastern wall of that building was comprised of glass, which caused some concerns because of the risk of injury and death to the DPP and his staff, in particular, the 3 upper floors of the building. 4. The DPP, when he viewed the building for the first time, informed the representatives of the government that although the building was spatially suitable and there were parking spaces for the staff, the building had to be assessed by the special branch unit of the TTPS before steps were taken for him and his staff to be relocated at that building. The DPP referred to the physical securities unit of the special branch of the TTPS as that was the unit which made assessments of the security vulnerabilities of buildings to be occupied by public officials. Government used that unit to conduct security assessment of buildings before the buildings are occupied by public officials, including officials such as the President, the Prime Minister, and the Chief Justice. I would now address you on the reports of the expert unit of the special branch of the TTPS. The first report of this unit of the special branch was given in 2020, and the branch thereafter conducted further assessments and issued reports on those assessments. The government knew since 2020 that the special branch had concerns about the use of this building for the office of the DPP, and that the special branch had made recommendations for the safety and security of the building, which was intended to accommodate the DPP and its staff. The special branch, in its vulnerability risk assessment of the building, concluded, among other things, that if the building were to be occupied by the DPP and its staff, there was a risk of a criminal attack on the building, particularly through the eastern side with a glass wall. It was the opinion of the unit that the building was vulnerable to high-velocity projectiles discharged by someone firing a rifle, and that there was a great line of sight from the hills which were nearby to the building, in particular the upper 3 floors. The special branch reports characterized the risk of injury or death to the DPP and the staff if they occupy the building as being highly probable, unless its recommendations for the safety and security of the building were implemented. This unit found that the building was located approximately 160 meters from the East Dry River area, which in itself posed an inherent risk. The unit also found that this area was considered a high crime area known for gang-related activities, especially firearm offenses. The unit also found that this distance should be taken into consideration in the case of any threat, and it is unlikely that a 9mm caliber ammunition will be used by any potential perpetrators from this area, thus making the installed glass ineffective against other commonly utilized caliber ammunition, such as 40 caliber, 45 caliber, 5.56 and 7.62 ammunition. The special branch unit recommended that a higher level ballistics proofing had to be used on all the glass windows on the eastern side of the building. The unit, in its report, stated a critical assessment loss analysis, which was conducted in August 2020, and that stated the following. 1, in respect of people, that is loss of life, personal injuries, etc., the risk was high risk. Secondly, information, loss of damage to critical information, again, the risk was high risk. Processes, that is interruption of critical services resulting in prosecution delays, the risk was high risk. Equipment, loss of damage due to sabotage, high risk. The risk was high. So in all these matters in which the office of the DPP would be relevant to have services about, the risks were high. The DPP took the position that given the security concerns expressed by the special branch unit in its several reports and the failure of the government to fully implement those recommendations, any direction from the government for the DPP and its staff to occupy that building, if complied with, would have exposed him and his staff to huge risks to their safety, for which he and the government would ultimately have been responsible. The documents show that the rental agreement for this building expired on the 30th of April 2022. That meant that the government decided to enter into this agreement to rent the building in or about April 2019, because the rental was for 3 years. That also meant that the government entered into the rental agreement for the building without the government having the requisite security clearance from the special branch that the building was safe and secure to accommodate the DPP and his office. The government rented the building in 2019, therefore without getting security clearance from the special branch. The facts show that in October 2022, the special branch report, which was received in July 2022, recommended the construction of concrete block walls on specific areas of the upper floors of the building as an added security measure for the protection of the staff of the DPP. Upon receipt of that report in July of 2022, a site visit was conducted in August 2022, at which the Attorney General, the DPP, the Deputy DPP, and other representatives of the ministry were present. At the end of the visit, there were discussions amongst them, and they arrived at a consensus that the said recommendations for the construction of the concrete block wall contained in the report ought to be implemented. On the strength of that consensus, representatives of the ministry, including the Attorney General and the Property and Real Estate Services Division of the government, attended a meeting with the owner of the building, together with the representatives of the owner at the site of the building in September 2022, in order to discuss the commencement of the proposed security measure. At that meeting, it was agreed by all the parties that the construction of the concrete wall should be commenced. On or around the 17th of March 2023, the information shows that the owner would have resigned, and shortly thereafter he instructed that all further constructions and/or alterations to the building should be stopped. The facts also show that the DPP did not know that the rental agreement for the building was entered into by the government in 2019. The DPP became aware of that sometime thereafter. The reason which the DPP has given for not occupying the building with the staff is the non-implementation of the recommendations made by the special branch pertaining to securing the areas of the building which were in light of sight of ballistic attacks. The facts show that although the government did not fully implement the recommendations of the special branch reports for the building, the expiry of the rental agreement, and the fact that the building was not occupied by the DPP and its staff, the government wanted, notwithstanding all of those matters, to extend the rental agreement. The government made a request of the DPP as to whether he had any objection for the government renewing that agreement. And the DPP responded in writing that he had no objection, but that his non-objection was subject to all of the security concerns raised and recommendations made by the special branch in its several reports pertaining to the glaring vulnerabilities of the building. These facts raise relevant questions to be asked. Important questions arise from these facts. I have stated three, and I'm sure there are many more. One, why did the government enter into this rental agreement for the building without it first obtaining from the expert unit of the special branch of the TTPS a vulnerability risk assessment review of the building? Two, if the government had gotten such a report in advance of deciding to enter into the rental agreement, the government would have been able to include in the agreement a term that the owner consented to allow the government to carry out all of the renovations, alterations, recommendations to the building in order to comply with the recommendations of the special branch reports. 3, why did the government service the payment of the electricity and rental bills for the building, since the owner handed over the keys to the ministry in 2019, and before there was any occupation of the building by the DPP and its staff? The next heading I want to address you on is that NITCO, the government-owned company, came into the picture, but it came into the picture to provide security services. The special branch had proposed 2 options, and instead of the recommendation of the special branch, the government officials would have referred the matter to the then Minister of National Security, and thereafter the matter was referred to the National Infrastructure Development Company Limited, NITCO, a state-owned company. Subsequently, in a meeting arranged by the Ministry of the Attorney General at the building site, which included officials from several ministries, the special branch, and the DPP, NITCO personnel made proposal for the shoring up of the vulnerabilities of the building, while shockingly admitting that they had not seen the special branch reports. On the 31st of January 2022, in a meeting of the Criminal Justice Committee, which was chaired by the Honorable Chief Justice, Mr. Ivor Archie, and at which in attendance were the Attorney General, Mr. Faris Al-Rawi, the Honorable Minister of National Security, Mr. Fitzgerald Hines, the President of the Law Association of Trinidad and Tobago, Ms. Sophia Choate, the Commissioner of Police, Ms. MacDonald Jacob, and other major stakeholders in the criminal justice system. The DPP had indicated that by letter from the special branch dated the 18th of January 2022, he had been apprised as follows, and I quote, "The option exercised by NITCO was not the appropriate option to meet the security concerns, and that another option, option 2, as proposed by the special branch, had been the appropriate armor level to install so as to mitigate the risk while bolstering safety and considerably decreasing the likelihood of penetrating projectiles from the high-powered weapons from the East Dry River area." He was also apprised that the option exercised by NITCO was unsuitable for the existing environment, since its armor level can only withstand 9mm ammunition and not high-caliber projectile. The effect of all of this showed, therefore, that the special branch recommendations were the recommendations for the government to follow, and not anything that came at that time from NITCO, because that was unsuitable. The DPP has given explanations for not occupying the building. And I'm addressing this because the DPP has been accused of not responding to the issues raised by the government for him and his staff to not occupy the building. But the facts instead show that these accusations do not have any foundation. They are inaccurate and they're unfair. The cabinet appointed a committee, a one-person committee, Ms. Sandra Jones, to investigate the circumstances surrounding the non-occupation by the DPP of the Park Street building. That investigation was conducted. There is a document which I've seen, which itemizes what transpired at that investigation. It consists of 11 pages and shows the question asked by the investigator of the DPP and the members of his team, and the answers given by them to the investigator. The DPP cooperated fully with Ms. Jones. At page 11 of that document, in response to the question to the DPP of the factors which impeded the DPP from occupying the building from 2020, the DPP stated, amongst other reasons, that one of the factors which impeded the occupation of the proposed office was the non-implementation of the recommendations of the special branch pertaining to securing the areas of the building which were in the line of sight for ballistic attacks. The DPP also attended a meeting of the Joint Select Committee of Parliament on National Security held on the 19th of April 2023. At that meeting, he stated that having regard to where the building was located, it would have been the subject to certain risks, and that he wanted the expert unit of the special branch to do a security vetting of the building. That was done. At least 6 reports were provided, which listed the observations of that unit. That meeting of the Joint Select Committee, which carried his comments, were aired live and was reported on extensively. The DPP informed the Joint Select Committee of Parliament that he was not able to go into the details of the special branch reports at that meeting, but that his reluctance to take his staff into the building was predicated upon what the experts stated in the several special branch reports about the building, and that the building and that the recommendations of the special branch had showed up the vulnerabilities of the building. Now, there's an important legal issue to understand in relation to the DPP and the special branch reports. The DPP was legally handicapped to respond to criticism made against him because he was not able to make available to the media or to the public or to anyone for that matter a copy or access of the special branch reports to show the security concerns and recommendations made by the special branch. Those reports contained conditions precedent to be satisfied in order for the building to be safe and secure for the occupation of the DPP and its staff. Those reports are private and confidential, and they specifically state on them that they cannot be disclosed without the consent of the Commissioner of Police or a delegate of the Commissioner of Police. It is only yesterday, the 8th of November 2023, that the DPP received communication from the Commissioner of Police that approval has been granted to him to publicly use the reports provided by the Special Branch Unit of the TTPS. I can assure you that the relevant principles of law did not permit the DPP to disclose the contents of these reports to the media or to anyone without the permission of the Commissioner of Police or her delegate. The entitlement of the DPP, in my opinion. The DPP is and was entitled in law to rely on the contents of the special branch reports to not occupy the building on the ground that to do so would have exposed him and his staff to the risk to their lives. The law imposed a duty on the DPP towards his staff for him to take reasonable care to avoid any injury to them and for him to protect them from the risk of injury. The duty of care was a duty to take all reasonable steps to provide his staff with a safe system of work. That duty of care has been described by judges in the decided cases throughout the Commonwealth as a duty not merely to provide his staff with a safe system of work, but a duty which required the DPP also to establish, maintain, and enforce such a safe system of work in favor of the staff. The independence of the office of the DPP. Section 90 of the Constitution of the Republic of Trinidad and Tobago makes the DPP solely responsible for the institution of criminal proceedings in Trinidad and Tobago. The DPP also has the power to take over any criminal proceedings instituted in Trinidad and Tobago. The DPP is given by the laws of Trinidad and Tobago security of tenure. That security of tenure given to the DPP is by the Judicial and Legal Service Act of Trinidad and Tobago, Chapter 601. That is the same law which governs the appointment of judges of the Supreme Court of Trinidad and Tobago. The DPP cannot be removed from office by any government or by the whims and fancies of any public official. Any disciplinary proceedings to be launched against the DPP must be instituted in accordance with the Judicial and Legal Service Act. The Constitution expects that the DPP would not act under the direction of any person in initiating or discontinuing criminal prosecutions. As stated above, the office of the DPP owes its legal authority to Section 90 of the Constitution of Trinidad and Tobago. In carrying out this mandate, its officers have on many occasions had to deal with threats of violence by very dangerous criminal elements. The criminal landscape in Trinidad and Tobago today seems to provide fertile grounds for the execution of these threats, and it is not unknown that persons involved in the profession of prosecution of criminal offenses are liable to fall prey to these elements. In this regard, the death of Dana Sita's senior counsel has to be remembered. The United Nations, at its Congress on the Prevention of Crime and Treatment of Offenders held in September 1990, issued guidelines on the role of prosecutors. At page 2 of those guidelines, it states as follows, and I quote, "Prosecutors, as essential agents of the administration of justice, shall at all times maintain the honor and dignity of their profession. States shall ensure that prosecutors are able to perform their professional functions without intimidation, hindrance, harassment, improper interference, etc., etc." End of quote. This country faces a serious challenge with the spiraling rise of crime. In order to effectively combat that problem, it is important for the government to have all hands on deck. What do I mean by all hands on deck? I mean the government, the police, the DPP, and all other state agencies which impact on the need to fight crime, must be on deck. The prosecution of criminal offenses is an integral part in the fight against crime. In my experience as an Attorney General and Minister of Legal Affairs, at a time when the country faced serious challenges in the fight against crime, at a time in which Trinidad and Tobago was branded abroad as the Wild West, I realized and I recognized that in order to fight that problem, it was important for all hands to be on deck in the fight against crime. The facts ascertained show that the Cabinet of Trinidad and Tobago agreed that in order for the government to have an effective fight against crime in Trinidad and Tobago, it was necessary for the Cabinet to increase the number of lawyers and administrative officers and the staff of the office of the DPP. It recognized also it was necessary for that office to be relocated for the DPP and the staff to be able to play their role in the prosecution of criminal offenses to assist in the fight against crime. I believe it is important in the public interest for the government, the police, and the DPP to work together to make this country safe. It is hoped that notwithstanding these events, there can be a united front by the state agencies in the fight against crime in this country. This is affecting the lives of every individual in Trinidad and Tobago, and it must be addressed and redressed. Conclusion. The DPP did not have any input in the decision made by the government to enter into the rental agreement of the building, which the government entered into 2019. The DPP, therefore, cannot be blamed for any such thing, and not to be blamed for any rental that was paid from that period. The DPP also did not have any input in the decision of the government to pay any rentals for that building after the tenancy expired. The DPP also did not have any input in the decision made after the lease rental had expired for the government to consider renewing the lease rental. The reason the DPP did not occupy the building was because of the contents of the several special branch reports and the non-implementation fully of the recommendations contained in those reports by the government. If the DPP and its staff had occupied the building in those circumstances, it would have put their lives at huge risk. In the investigation conducted by Sandra Jones, pursuant to the decision of the Cabinet, one of the questions which she posed to the DPP was as follows. I will state what the question is, and I would also state what the DPP's answer was. Question, open quotes, from a leadership position and project management perspectives, what are the lessons to be learned by decision makers with respect to the involvement of key stakeholders from the planning and implement stages of the project? End of quote. Answer of the DPP, open quotation. Some of the lessons which may be learned from the project are: 1, the time from selecting the building to its eventual outfitting and readiness for occupation was inordinately long. 2, the core business of the office to be relocated must be borne in mind in selecting a suitable area for relocation. 3, safety of the lives which occupy the proposed site must assume primacy over any other consideration, least of all the costs of the rental or the lease. 4, greater collaboration and more open communication between the stakeholders, especially the special branch, and the person tasked with outfitting the building may have reduced the delay. This is of particular importance when the special branch could make the necessary recommendations which would inform the choice of materials to be used and the possible areas of weakness in the need of fortification from the standpoint of security. And 5, any building or proposed site to house key stakeholders in the administration of justice should of necessity include a risk assessment report from the special branch at the stage of selection and outfitting. End of quote. Thank you very much.